Welcome back. You're watching HFO-TV.
Welcome back to HFO-TV. I'm Greg Frick, partner at HFO Investment Real Estate. Again, we're lucky to have with us John DiLorenzo of Davis Wright Tremaine. We're going to talk about, he's actually representing More Housing Now, and he's also the lead counsel on the legal challenge of the City of Portland's relocation fees that got put in last year. So we're going to get a little update on that. Thanks again for coming back.
Thank you, Greg.
Always very informative. Why don't we give a little update to the audience? We're at the end of February of 2019, where we are with SB 608, the Senate bill regarding the rent caps and the relocation statewide.
Right. Well, Senate Bill 608 is a very complicated bill.
Yes.
But it does a number of basic things. First, it controls what are called no-cause tenancy terminations or no-cause evictions. And it basically provides that after a tenancy is older than a year, you can't have no-cause evictions unless they are very specific exemptions
For the no-cause.
For the no-cause, including major repairs that need to be made to, to a unit, things like that. So there's that side of it. And then there's the statewide rent control side.
Right.
And the legislature years ago passed a bill that provided that rent control was a matter of statewide concern and was not an area that local governments could involve themselves in. In fact, the statute says no local government may enact an ordinance that controls rent.
And that's, again, statewide within the state of Oregon.
And that's statewide within the state of Oregon. So 608 has not changed that.
So the exemption is still in place?
Right, the preemption is still in place. No local government may enact ordinances that control rent. However, the legislature has now taken the position that it had years ago said that rent control was a matter of statewide concern, and they are imposing rent control statewide. And the way they're doing it is to provide that there can be no rent increases beyond, in any one calendar year, beyond 7% plus CPI West. So in the Portland area, that amounts to about 10% per year. And so that bill has many problems associated with it.
Now, there are some exemptions.
There are some exemptions.
Right. There's a new construction exemption for 15 years.
Right, and it's not really new construction. It's any
Building,
property that's 15 years old or less.
Will be exempt.
And that's going to be a rolling sort of a thing.
Right, so you'll fall off at...
You fall off,
Got it.
right, at the 16th year.
Got it, okay.
Right. And if you own 1 to 4 units only, you're exempt.
From the rent control cap.
Right, right. Now, what's interesting is this is unlike New York or some jurisdictions in California where we don't have vacancy control in this bill. So the units themselves are not rent controlled. The rent control is personal to the tenant.
Gotcha, okay.
So if a tenant on their own, for some life reason, decides to take a job somewhere else or some other reason and moves, the owner can then increase the rent for an incoming tenant up to market.
So you're not capped on a vacancy control component, right?
Right. So, any owner who is keeping up with market is not going to be immediately affected by the rent control because there are very few instances in which, a landlord would raise their rent 10%. Unless you've been a landlord who's been just an awful good guy and has enjoyed your tenants and they've been there for 15 years and you've never raised the rent, and now all of a sudden you're going to be stuck way below market, which, it stands for the adage that no good deed goes unpunished.
Without the ability to get to rent.
Exactly.
The market.
Exactly. So,
okay.
So that bill just passed today in the House of Representatives. It has an emergency clause.
Why don't you explain a little bit to people what is the emergency clause and what that does? Because I know that's something, once we kind of figured this was going to go through, trying to fight to get that out, and give a little update on that.
We tried to take the emergency clause out in the Senate, and the Democrat leadership told us no. We introduced amendments in the House, and they all failed.
And the emergency clause states that once it's signed
By the governor, it's effective immediately.
that day.
That day, that moment.
So if everything changes that day.
This bill is on the governor's desk right now during this interview.
Okay.
Were the governor to sign it in 5 minutes, it would be the law in 5 minutes.
We would walk out of here and we went, gotcha.
It would be the law.
Okay.
We are also actively lobbying the governor's office to veto the emergency clause. Under the Constitution, the governor has the right to veto emergency clauses only off of bills.
Gotcha. Okay.
If the governor takes us up on our request to veto the emergency clause, then this law will be effective in January with the other laws. So this is why we're asking her to veto the emergency clause. The penalties for violating this very, very complicated bill are severe. Violations don't really rely on intent. It doesn't matter what a landlord intended. If you did it, you did it. The penalties are 3 months' rent, plus actual damages, plus the tenant's attorney's fees. Okay. So, you know, if you make a mistake and you didn't know it was the law, and if the first notice you have is a demand letter from legal aid, you are potentially liable for 3 months' rent, plus actual damages. So let's say rent's $1,000, that's $3,000. Tack on maybe another $1,000, that's $4,000, and then tack on $10,000 for the attorney's fees.
Right.
And so, you know, you're at a $15,000, $16,000, $17,000 nut.
Now you've been involved in a lot of politics over the years. Is it odd to have a bill go through that's got a lot of administrative and contractual stuff without any amendments, where you've got vested parties that deal with this on a daily basis to come or to talk about, you know, this doesn't work or this is not leading, you know, was it kind of odd in how this thing kind of got through like this?
I have been lobbying the legislature for 35 years during Democrat administrations.
Started when you were like 12.
Republican administrations. Oh, aren't you nice? Democrat administrations, Republican administrations. I lobbied bills when the Republicans had the House and the Senate under control. I cannot recall a time when committee chairs have been so brazen as to say in advance, it doesn't matter what the testimony is, there will be no amendments, and this bill is going to pass as written. Now, maybe some of them have thought that in the past, but no one has been brazen enough to acknowledge it.
Right.
And this group has. So that's what we've had to deal with, which is why we're petitioning the governor to
at least give us time to get
give us
ready.
Time to, well, here's the reason.
Rental forms.
Well, here's another reason. A lot of landlords rely on printed forms.
Yes.
It's going to take those form committees a while to figure out what this bill means before they actually decide to write the language in the forms. So, which means that if the governor signs the bill today or tomorrow, by definition,
it's in place.
Everybody has forms that require updating, and they're not going to know what to do. It's a very unfair situation.
Yikes. Now, which leads me to the city of Portland, which, you know, they've had their city relocation fee. You're the lead counsel on the legal challenge of that. Right. How does this play on, because again, 608 statewide, city of Portland had their relocation fee. What's kind of the intersection with these two, where we are with that?
So, under Senate Bill 608, if you evict a tenant for one of those enumerated landlord reasons,
right?
Let's say you need to remodel the unit, okay? And you evict the tenant because you need to remodel the unit. You have to pay 1 month's relocation under
608.
Under 608.
Right.
There is nothing in 608 that does not say that local governments cannot pile on top. So, given the current state of the law, if you either raise the rent more than 9% or more than 10% in Portland, or if you issue a no-cause eviction, which you cannot do now under 608, but you can under one of the landlord permitted reasons.
Right.
So let's use the remodeling example. If you do that, you will owe the 1 month's rent under 608 plus the relocation fees
In the city of
in
Portland.
the city of Portland, if you do this in the city of Portland. Now, the city of Portland portion is currently in litigation.
Right, which we've, right.
Right. And we just argued our case about a month ago in the Court of Appeals. And here's our theory. The city of Portland has not passed a relocation ordinance that affects all tenancies. Rather, they have used it as a punishment, as a hammer for doing one of two things, either a no-cause eviction or raising rent more than 10%.
Right.
So, I mean, they could have come up with many other consequences. They could have said there's a $5,000 fine. They could have done any number of things, but they said, no, you pay relocation if you raise rent 10% or more. So they tied it to the rent increase. Well, we're arguing that that is by definition an ordinance that is designed to control rent. And therefore it offends the preemption provision, which Senate Bill 608 has not disturbed.
Again, because 608 kept the preemption in place.
Kept the preemption for local governments.
Right.
But allowed it for the state.
So what, is there a timing on the ruling on that from the city of Portland? I know we're in the Court of Appeals. I mean,
The Court of Appeals has the case. It's been submitted. It's all been briefed, all been argued. Now it's just up to the court to determine when it's going to issue an opinion.
Right.
These opinions take anywhere from 6 months from oral argument to 8 to 9 months. So sometime, around the first year, I imagine we'll have some decision.
then, but again, like I said, with the emergency clause not out, if the governor signs it today, tomorrow, next week, we're going to have this period where it's nobody's had time to get the forms ready. And again, we try to notify people what's going on, but there's a lot of owners that don't know. I think there's a lot of tenants that don't know kind of the change. So it's going to be interesting how this is all going to work for the next 9 months.
I told the governor that this is a trap for the unwary.
Yes.
And the penalties are so severe that it would just be unjust to not have a period of time in which landlords could come up to speed. Now, the tenant community are emailing the governor saying, oh no, we don't want landlords to increase rents right underneath the gun here. So,
which you can't do if you're on a lease. You can't do that anyway.
Can't do that on a lease anyway. And you know what? If that happens, that's going to happen in very few buildings.
Right.
But I think by having an emergency clause in that bill, the governor is creating a cottage industry of lawyers who will hunt down landlords who have been in violation and will make their attorney's fees and 3 months rent plus actual damages, and it's just not a healthy situation.
Now, I know the other thing the city of Portland has is they've done thoughts on renter screening and security deposits.
Right.
What's your kind of thought on where that is and where it may go? And because I know the state's not really touching that yet.
Right. Well, what are they up to? Like the 14th draft of it now?
14th or 19th,
and,
I think.
I can't keep track of the number of drafts anymore. I can tell you that I'm surprised that tenants aren't more concerned about these screening criteria. I mean, if I were, and I used to be a tenant for, I don't know, probably first 10, 12 years practicing law, I was a renter. And I can tell you, I would not want to have a serious felon living next door to me. These screening criteria are more designed to preserve the community, the ambiance of the community, because landlords don't want communities that are in disarray.
Right.
They want stable communities, as do tenants. So this is an area where landlords and tenants ought to be aligned.
But I think a lot of legislation that's come through, as somebody was at one of our events quoted, it's kind of weaponized the relationship between landlord and tenants, which is not, and again, like you said, there's more times when they're aligned. Right. You're going to have, you'll have a tenant there's issues, you can have landlords, but for the most part, you've got 90% of them are in line in that, and that they've put it like this is not, I don't think it's going to be a benefit to the landlord, and I sure don't think it's going to be a benefit to the tenant. We've discussed, we don't have that many landlords that do a no cause to raise rents.
That's true.
I mean, there's been no causes to get a bad tenant out, to help other tenants in terms of that. But again, it just seems like it's kind of gone on deaf ears. And then the way it's been slammed through, like you said, you've never seen this in 38 years of doing this.
Right.
Which is a little sad. So, well, if you want more information, come to our website. We have John's contact information as well. Again, this may be in law by the time we're done with this interview, if the governor signs it today. We're hoping we can get an emergency clause put in there and we can, push this out a little bit. But again, it'll be very interesting to see how this all works and what happens in the city of Portland. So again, thank you, John, for coming and
you're welcome. Thank
enlightening
you,
our audience.
Thank you for having me.
Thank you. We'll see you again next time on HFO TV.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.